Individual jurors, and indeed juries as a whole, may have a poor understanding of the science that is presented in the courtroom, which could lead to miscarriages of justice, wrongful convictions, or wrongful acquittals. This, in part, may be due to the increase in the availability and regularity of using forensic identification and detection methods that results in a greater number of cases being presented to a jury of laypersons in the modern age. New forms of scientific investigation may not easily be comprehensible if a jury has not encountered the process before and cannot intuitively identify the possibilities and limitations that exist. Conversely, a layperson may be ill-informed of both new and long-standing techniques due to the CSI effect, whereby modern entertainment reflects an inaccurate view of technology and other scientific capabilities. The purpose of a jury is to decide on issues of fact. The judge will decide on issues such as the admissibility of the evidence, but a jury's decision relates to the credibility and reliability of the evidence presented to them. Sometimes this may be eyewitness evidence, but it may also include scientific evidence. The purpose of an expert is to assist the jury in understanding scientific or technical evidence. In Scotland, as in England and Wales, there is no equivalent to the Daubert criteria used in the United States for admitting expert evidence, but the following quotes do help to understand how and when the jury can be presented with scientific detail in this jurisdiction. The Lord President Cooper in 1953 said that the expert's duty is to furnish the court with the scientific criteria to enable independent judgments to be made by the jury, but, notably, their evidence must be taken along with the rest of the evidence, if other evidence is presented. This quote comes from an English case, which is also known as the Turner Rule, often cited as a barrier to psychological expert evidence being presented in court. In particular, this case reinforces the point that an expert is only ever required to assist the jury, and it adds some caution that jurors may lend too much weight to an opinion, as it emanates from an expert and is an opinion. This presentation aims to review some of the possible pitfalls facing juries when expert scientific evidence is presented in court, and also the pitfalls that may occur when such evidence is not led. A recent UK Ministry of Justice report indicates that jurors' understanding of legal terminology is variable, and that jurors do use the internet to look for information about their case. One particular study involved 797 jurors at 3 courts who all saw the same simulated trial and heard exactly the same judicial directions on the law. There was not a consistent view amongst the jurors about their ability to understand the judicial directions. Around 70% of jurors in one court felt they were able to understand the directions, whilst 50% at another felt the directions were difficult to understand. Jurors' actual comprehension of the judge's legal direction was also examined. While over half of the jurors perceived the judge's directions as easy to understand, only 31% actually understood the directions fully in the legal terms used by the judge. Younger jurors were better able than older jurors to comprehend the legal instructions, with comprehension on the directions of the law declining as the age of the jury increased. And all jurors who looked for information about their case during the trial looked on the internet. Most jurors said they saw information on the internet more than those who admitted looking for it on the internet. The report's author raised a number of questions that should be examined further. Do jurors realise they are not supposed to use the internet? How do they use the internet? Do they just look for information, or do they also discuss the case on social networking sites? And finally, what type of judicial instruction would be most effective in preventing jurors from looking for information about their case on the internet? There have been many recent reports relating to jury impropriety and the use of the internet by jurors, as illustrated here by media reports. The judiciary have also expressed concerns about this, and the Lord Chief Justice of England and Wales has opened debate as to whether legal procedure should be adapted to suit the computer generation. And this is a problem worldwide, not solely in the UK, as this example from the US illustrates. Whilst texting, email and other one-to-one communications can quite often be private between individuals, where it would be difficult for a court to be alerted to improper conduct by a jury, both Twitter and Facebook are less private forms of social communication. Here, users are encouraged to report on what's happening. However, the public nature of these communications is significant. Anyone can access these tweets, and many users can follow other users, as illustrated here by popular figures and the thousands who follow them. But anyone can view the content, without necessarily being a follower. Here, a variety of search tools can also be available on home PCs, iPhones, and many other devices, which makes information more accessible. Indeed, there's almost a natural tendency for members of society with access to the internet to instinctively look up information they do not have and may require. Historically, a juror, up until the 21st century, would have had to take considerable time and effort to source external information regarding an accused or a legal agent, or any data regarding the reliability of scientific methods. The ease of access to information via search engines and repositories has facilitated this change, but also the improvements to mobile technology and the widening of digital engagement has led to a culture shift, where citizens can research what they don't know or understand with relative speed and ease. Although a problem has been identified, the solutions here remain unclear. Daly and Edwards highlight several cases that have collapsed due to jury impropriety, and note that these cases are only likely to be the tip of the iceberg, that appeal courts see only those cases where the impropriety has come to light. Despite this, they note that the English Court of Appeal has distinguished cases where jury research has been of concern, yet not sufficient to render the conviction unsafe. In Hawkins, for example, it was argued that the legal distinction made by the court in relation to internet information that was accessed by a juror was only peripheral to central issues, and the appeal was dismissed, whilst in Marshall, a juror accessing information regarding sentencing and charge was seen to be a matter of considerable concern, and the appeal here was allowed. The argument here, being perfectly coherent to the legal community, does, however, present itself as a rather mixed message from the Court of Appeal for non-qualified members of society. One may ask, how can this be remedied? Certainly the Ministry of Justice report identified that further work was needed to look at what type of judicial instruction would be most effective in preventing jurors from looking for information about their case on the internet. As an example, the Ohio State Bar Association Jury Instructions Committee has prepared specimen directions that a judge may use to address a jury on this matter. These include a warning on outside information, such as a ban on sources outside the courtroom, talking to family, friends, but also the internet, reference books, newspapers, magazines, television. Warnings on outside influence, to exclude misleading or outside influences on information, especially popular TV shows such as Law & Order, Boston Legal, Judge Judy, older shows like LA Law, Perry Mason or Matlock, and other fictional shows. They may include warnings on outside contact. This also includes sending or receiving email, using Twitter, text messages or other similar updates, blogs, chat rooms, the use of Facebook, MySpace, LinkedIn and other social media, and these examples are listed within the specimen direction. How then might alternative remedies be put in place, as the media reports identify cases where judicial directions may have been ignored or have fallen on deaf ears? If we think about the possible reasons why jurors are looking for information, it may well seem logical that they are, or feel that they are, ill-informed, lost or confused by what is presented to them. One possible remedy would be to improve the quality of scientific information presented by the expert, so that a jury would not feel the need for further information. This is one particular important area where the prosecution or the defence choose not to lead scientific information, but a jury suspects that such evidence should be led. An alternative, should an expert not be asked what the jury consider to be the relevant questions, then should the jury be encouraged to ask questions formally. This, however, may infringe upon the function of a jury, which is to try the case on the evidence presented, not on the evidence that they think should have been presented, and rather detracts from the adversarial nature of the law in common law jurisdictions. A possible solution, if indeed jurors are looking to the internet for comprehension and further understanding of the science, may be to construct or provide generic supports that are not subject to error, as popular TV culture can be, misinterpretation, as valid reference sites may well be, or prejudice, as family or friends, on or out with social media networks may be. Certainly such resources can be approved by the court, the judge or the legal teams to ensure that the jury are receiving relevant information, but perhaps in a format that they can understand more readily than the expert stood speaking in the witness box. To summarise, however, these possible remedies are not necessarily straightforward. They only work on the assumption that jurors are looking to the internet for information and comprehension. There is, in the UK, a general ban on researching jurors, juries, and their deliberations under the Contempt of Court Act of 1981. The Ministry of Justice report is the first of its kind, and may lead to further research as the limitations of the statute become clearer in relation to jury research. If we can further understand the problem, there may still be a barrier to implementing solutions, as indicated in the last slide in relation to the adversarial legal tradition of trying the case on the evidence presented alone. Likewise, it may also be difficult to evaluate whether a solution is effective, as any research inquiring into the decision-making process would most certainly be unlawful and in contempt of court. My final point in this presentation is that some improvements could potentially be made, even if we are unable to measure the universality or extent of the problem. Access to information has changed, and so must the legal system, whether by judicial instructions or the provision of further materials. Otherwise, our belief in the justice system may well be undermined.